I am looking at Rule 6 of the Federal Criminal Rules of Civil Procedure. And everything that was in the actual motion is actually in the Federal Rules of Criminal Procedure, Rule 6, the grand jury. And it's pretty fascinating stuff. I can't tell you, I can't express to you how fascinating this stuff is, but it's pretty damn fascinating. I'm not even gonna lie to you. Like, the possibility that this guy could get off is just crazy because of the way the grand jury works. So let's just go ahead and get into this, right? So I'm not going to read all of this. I'm just going to skip. I'm just going to try to speed this up because we've already read the letter and you know the gist of it. Basically, he's saying the imposter is saying that number one, the grand jury wasn't properly formed. Number two, the grand jury didn't follow the proper procedure. And number three, there's no evidence of a grand jury, right? So those are the things that he's claiming, if I can remember it correctly. But here's the thing: you would never know whether or not any of that stuff is true because a grand jury is bound to secrecy. No obligation of secrecy may be imposed on any person except in accordance with Rule 6E to B, right? And this is basically, you know, that rule for secrecy. And it goes on, unless these rules provide otherwise, the following person must not disclose a matter occurring before the grand jury. Number one, a grand juror. If you're on the member of the grand jury, you can't disclose any of the things that actually took place. Then number two, if you were an interpreter for the grand jury, you can't disclose anything that actually took place. Number three, if you were the court reporter attending the session for the grand jury and you were recording the details, you can't disclose the proceedings of the grand jury. Number four, an operator of a recording device. That means that, if you went in there with a device to record the proceedings, you can't disclose the proceedings of the grand jury. And then number five, a person who transcribes recorded testimony, meaning you get the recording and you're taking the recording, you're putting it on paper, you can't disclose the proceedings of the grand jury. Number six, an attorney for the government. That the attorney couldn't, the prosecutor couldn't disclose the proceedings of the grand jury. Number seven, a person to whom disclosure is made can't disclose the proceedings of the grand jury. So in other words, if for whatever reason you had the right to get the details of the grand jury in your official capacity and someone told you the secrets, by law they were supposed to tell you, you can't go off and tell anyone what was in the grand jury. So now the secrecy clause, or the secrecy portion of the grand jury, is kind of funny, and I'm going to get into it in a minute, but let's talk about why there's a reason for secrecy. So I read the case law and I just don't want to keep flipping back and forth, but essentially the purpose of the grand jury is to number one, protect the jurors and protect the tradition of a grand jury. And the logic behind that is that you want to protect the jurors in the event that, to avoid the event that their names could get out before they actually go to the proceedings and make a decision, because people could actually intercept them and threaten them, so on and so forth. So they want to protect them, right? And then after the fact, they want to protect the grand jury, or the people in the grand jury, because they could be embarrassed by the decision they made. They could be, they could, there's other statutes and there's other scenarios in which they could lose their job, or they could be negatively impacted because they participated in the grand jury. For example, let's just say that the grand jury decides to impeach Trump, right? And it comes out that Joe Blow was a member of that grand jury. Well, Joe Blow could be attacked in the future, even though the trial is over and the case is over and done with. It comes out that Joe Blow actually voted to impeach Trump. Then Joe Blow could probably be attacked by people. So that's just an example, right? I'm not even sure they need a grand jury to impeach Trump, but that's just an example. So they want to protect the tradition of the grand jury. So I had to throw that out there, but that's case law. That's what case law says. Now, all of that is funny because as a defendant, you have a right to object to the grand jury or a grand juror, which is kind of funny because how are you going to object to it if you don't know what actually happened? So that's where this whole thing just takes this bizarre turn, right? And actually, before I even get into that, we talked about the secrecy, and then there are these exceptions to that secrecy. And most of these exceptions are for the government prosecutors, for example, an attorney for the government for use in performing that attorney's duty. They can disclose the information, so on and so forth. And all of the bulk of this is going to be for the exception of the government. But at the request of a defendant who shows that grounds may exist to dismiss the indictment because of a matter that occurred before the grand jury. So there's an exception in the rule that you can have the grand jury challenged based on something that happened before, before because of a matter that occurred before the grand jury. And according to case law, one of the possible scenarios could be is that the grand jury was improperly selected. There's lots of rules of how you come across how you build a grand jury, and I'm not going to go too deep into that, but it's going to be similar to how they select the jury. They're going to take voters, and they're going to try to make it fair so that you're not getting a grand jury made up of a specific group of people, right? So that's one exception, that you want to challenge something that happened before, that occurred before the grand jury, right? And then, of course, it's in a defendant's right, according to the rule. I'm just reading what's in the rule. It is the defendant's right to challenge the grand jury, right? And then it goes on, objecting to the grand jury or to a grand juror challenges. Either the government or a defendant may challenge the grand jury on the grounds that it was not lawfully drawn, summoned, or selected, and may challenge an individual juror on the ground that the juror is not legally qualified. Now, there is a lot to this, and I'm not gonna, cover all that. I just really want to make this video as quickly as possible. But you get the gist of it. You can challenge either the grand jury itself or a particular member of the grand jury, right? So, right, and you can challenge them based on an argument that it was not lawfully put together, not lawfully drawn, based on the argument that it was not lawfully summoned, based on the argument that it may be challenged and you may challenge an individual juror, or the ground that the juror is not legally qualified. Maybe somebody in that jury pool shouldn't be there. Now, this is where it gets crazy, because how in the hell are you going to challenge the grand jury or a juror if it's a secret proceeding? You understand what I'm saying? That's what's so crazy about it. This whole thing is done in secret, so you don't have the ability to actually make any of these challenges because you don't know what the hell that has actually going on. Now, according to case law, it's in the judge's discretion to actually grant a motion to discover the 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 minutes of the grand jury. So more than likely, not more than likely, as you read in the actual imposter's letter, that they argued that the grand jury was not properly drawn, and they argued that it wasn't enough people, and they argued that uh, there's nothing on the record that the grand jury foreperson, and there's nothing on the record that says that the deputy grand jury foreperson actually signed anything. But you can't challenge that unless you unseal the record. So everything that happened, the signature of the actual foreperson and the deputy foreperson, all that stuff is sealed. So you can't challenge that. You cannot challenge that because it's in secret. So how do you actually get that information to come to light? Well, according to case law, that's extremely difficult to do. It's extremely difficult to get people or to get a judge to reveal anything about the grand jury, but one of the typical motions they make is a motion to disclose the minutes or the recordings of that grand jury indictment. And once you disclose the recordings, then the defendant can, make all these challenges, right? And then, of course, you have a motion to dismiss an indictment. A party may move to dismiss the indictment based on the objections to the grand jury, but you can't make this motion, right? That's one thing about the imposter's letter, is that it's actually skipping the fact that they have to first prove this part of it. And they do make the allegations that no objection, no grand jury indictment appears on the record. But how do you know that? It's sealed. It's supposed to be sealed. So that's why I say that in the parallel universe, R. Kelly's lawyers themselves actually filed this imposter motion, right? They filed the imposter motion with the intent of raising the issue so they can actually go before the judge and say, well, hey, this stuff was raised by an imposter, but now that we think about it, we need to actually unseal the recordings of the grand jury, right? And again, that's my conspiracy theory. I'm not saying that this happened, and this is something that I'm alleging went down in a parallel universe. So I'm not accusing any of his attorneys of actually doing this. I'm just giving a bizarre conspiracy theory out there, because to me it seems like you can't really bring this issue up in any other fashion, because according to case law, right? According to case law, is extremely difficult, very difficult, to get the judge to unseal the minutes of the grand jury. So that's one of my actual conspiracy theories. I don't know that I believe that R. Kelly himself actually wrote the letter. And the reason I don't believe that, because if he truly felt the words that were in the letter, if he truly felt the words that were in the letter, then he could just simply fire his attorneys. He could simply just fire his attorneys, and then he could present that information. So I don't see where Greenberg has been fired. I don't see where Anton has been fired. So to me, it doesn't make sense that R. Kelly could have written his letter. So, questions, comments below. What are your theories on who wrote the letter and why they wrote the letter? My theory, one of my conspiracy theories in a parallel universe, is that R. Kelly's legal team actually wrote the letter because into they're trying to introduce this subject to the court. and they're trying to find a way to introduce the subject to the court. So they play this card in the parallel universe. Again, in the parallel universe, uh, this conspiracy theory is that they play this card and they gauge the judge's reaction, and then they say, well, you know what, judge, we actually want to make a motion to unseal the grand jury's recordings, right? And we actually want to see the signature of the deputy foreperson or the foreperson himself to see whether or not everything was proper in this grand jury, right? Because there's no other way that they could actually do that without looking probably a little, I wouldn't even say looking foolish. I would say it's a long shot, right? Now, here's a funny thing. Despite the fact that an imposter wrote this, and let's just forget about my crazy conspiracy theory, I still think that now this is I'm actually saying that they should actually do this, right? They should actually write a motion to unseal the minutes or the recordings of the grand jury, because this is one of the ways to actually win the case. And this is in the pre-trial phase, I believe. Well, actually, according to this, you can do this at any time, but generally, historically, this has been done in the pre-trial phase. This used to be a pre-trial motion, but I think somewhere along the lines, they they made it so that you can do this at any time, right? And I think they need to do this. I think that R. Kelly's lawyers need to actually file a motion to object to the grand jury or grand juror, and to actually file a motion to unseal the grand jury indictment, so that they can go through it and just see if there's anything there that they can use, right? So maybe the imposter is actually, and of course another conspiracy theory is that there is an actual imposter, because in my opinion the motion was well written, in my opinion, right? Forget about the misspellings and all those other accusations. The argument is a valid argument, a very valid argument. The motion is well written. I believe that I believe one of the conspiracy theories is that there is an actual imposter, and that imposter is trying to force the court, and that imposter is actually trying to force R. Kelly's lawyers to actually take action. And the reason I say this is because the arguments are valid. The arguments are very valid. So of course they probably know what they did is fraud, but they said, you know what, I'm just going to do this anyway because I want these jokers to actually do something about this indictment. And if he and there's a there and if anything in that letter is true, then you have to let R. Kelly go, because you don't have a grand jury indictment. If you don't have a grand jury indictment, then you don't have subject matter jurisdiction to actually prosecute R. Kelly. So in that event, the prosecutors would have to, number one, first and foremost, release R. Kelly, and then they would have to go and get a new grand jury. And I think I had some chat back and forth between Big Daddy Lolo and myself, and he was asking, would double jeopardy apply? Double jeopardy would not apply in this situation because there has to be a trial. So of course they could always re-indict R. Kelly, but this would be a move that would buy R. Kelly some time to come up with a better defense, and it could possibly create other opportunities for R. Kelly if he gets a chance to get released. Of course, he knows another indictment is going to come, but there's always a possibility that if they put together a second grand jury, that second grand jury is going to be under a microscope, and there's always a chance that you're going to find yet another mistake that is made in the second grand jury that you can use to have that grand jury indictment thrown out. And then if there's always a possibility that a second grand jury may not choose to indict R. Kelly, right? So you create opportunities by challenging the first grand jury indictment, and if you're able to successfully do so, you create opportunities. R. Kelly would be out. He could better prepare himself. And of course, there's always a chance that the second grand jury wouldn't indict him. Then a second grand jury would be under a microscope, right? And of course, the government could always do something sneaky, is that they could realize that the first grand jury is no good, and then they'll expeditiously get a second grand jury. So by the time R. Kelly is able to successfully challenge the first grand jury, they'll have a second grand jury indictment already in hand and say, nope, keep them locked up. So there's a lot of possibilities, lots of crazy stuff going on with this case. Leave your questions and comments below. Let me know what you think about this whole thing. What is your conspiracy theory on what's going on with this imposter's letters and his motion? I want to hear from you. Please leave your questions and comments below. Please like, share, and subscribe.